Well, certain things flow from that, for better or for worse. That means the delegates are agents of the state legislatures. That means the delegates are subject to the instruction of the state legislatures. It means that the state legislatures have the power to determine how the delegates are selected. They can choose the delegates themselves or farm it out for election to the people. It means that each state gets one vote, and it means that Congress may not alter that process, as Congress has sometimes made motion toward doing. Well, you might say, isn't this really unfair? Does that mean that a small collection of states could change the Constitution? And I think the founders' answer to that was no, because democracy is protected in the ratification process. You need 3/4 of the states to ratify, and as a practical matter, whatever theoretical the numbers might say, as a practical matter, you can't get 3/4 of the states to ratify anything unless a majority, or probably a substantial supermajority of the American people favor it. So that's where democracy is protected. The next question is this a limited convention? Is it designed to deal with fairly narrow subjects, or is it plenipotentiary? And the answer to that comes from, again, loud and clear from the founding era, from authorities no less than James Madison. This is a limited convention. It's designed to accomplish specific purposes, and that is to propose amendments. And it follows from that further, and it follows from founding era custom, that the states may instruct their delegates, and the states may specify in their application what the scope of the convention can be. In other words, if the states say, we want a convention to propose a balanced budget amendment, that's it. The convention does not have authority to go beyond that. And again, if you look at the ratification era discussions, the evidence on that is overwhelming. Again and again, you see the assumption made by people at the founding that this convention not only can be controlled, its agenda can be controlled by the states, not only that it can be, but that it usually would be. So you see Federalist writers like Tench Coxe saying Congress must call a general convention even though they dislike the proposed amendments. Proposed by who? By whom? Proposed by the states of their applications. You see George Washington writing in 1788 that under the Constitution, a constitutional door is open for such amendments as shall be thought necessary by 9 states, the 2/3, in other words, necessary to apply. Unfortunately, some of the collections of constitutional material that have this ratification discussion in it have only been published in the last few years and have not been available to other writers. But if you go and you look at how people discuss the convention and proposed amendments, the message is clear. It is designed to implement amendment ideas that the states will propose. I will give one caveat, however. The convention is to be a deliberative body. The design was not for the states to say, okay, we're going to bring about a convention to propose amendments, and it's going to be a balanced budget amendment, and here's the text convention, vote on it, yes or no. That's not what was contemplated. But it was clearly contemplated that the states would identify general areas of concern and allow the convention to wrestle with them. Now, there are 2 common claims that I just want to hear over and over in this area that I just want to respond to very quickly, and then I'll wrap up. It is sometimes said, notably, for example, by Professor Walter Dellinger in an article a number of years ago, that for the first 100 years of our history, there was never a state application for a limited convention, and that therefore everybody understood that a convention had to be wide open. Well, there are 2 problems with that statement. Number one, what a state might have done in 1850 or 1830 is really not very good evidence of what the founders intended. The other problem with that statement is it's flatly untrue. There were, in fact, a number of specific single subject applications by states in the first 100 years. You can make an argument, I don't know if it's a winning argument, but you can make an argument that Virginia's 1789 application was for a limited convention. South Carolina's 1832 application certainly was. Alabama's 1833 application was designed to deal specifically with an issue of the federal taxing power, and Oregon's application of 1864 was designed to deal specifically with the issue of slavery. So if you hear that statement that during the first 100 years they were all general applications, just be aware it's not accurate. The second common, and even more common argument runs like this. You know, we had experience with a constitutional convention once before. Notice the word constitutional there. We had an experience with a constitutional convention once before, and it was a runaway. That was in 1787. Those guys were brought to Philadelphia to amend the Articles of Confederation, and they went out and they gave us a whole new form of government, didn't they? Well, of course, they didn't really give us a new form of government. The states had to ratify it. But the problem with that statement goes beyond that. The congressional call for the convention asked for amendments to the Articles of Confederation. But under the law of the time, the law of agency at the time, the scope of the 1787 convention was not set by Congress, it was set by the commissions from the state legislatures. And if you look at the commissions from the state legislatures and interpret it using 18th century legal and linguistic patterns, what you find is that 10 of the 12 states that sent delegates sent them with enough power to write an entirely new constitution. As to the overwhelming number of the delegates, the 1787 convention was not a runaway. It was designed to be a plenary or plenipotentiary convention, unlike the type we're talking about today. I'm going to finish up here by saying that more can come out later. But I do want to alert you to the fact there's a great deal more that can be learned about this process in history. Those people who are interested in using it, I strongly recommend that you look at the campaign for direct election of senators and how the states used the application process in that campaign to successfully accomplish what they wanted to accomplish. They had used a popular issue, understandable by state lawmakers. It was an issue on which Congress refused to act. They identified themselves, the advocates of direct elections said they were acting from founding era principles, and they carefully coordinated that campaign in a way that I think is a model for modern reformers. So even if you disagree with the 17th Amendment, even if you think that direct election of senators is horrible and we need to go back to the state legislatures, study that campaign. The progressives did a great job in using the application process, even though a convention was never held. Then I want to finish by just giving you two quick plugs. One is for a book called Constitutional Brinkmanship by Russell Kaplan. I picked up a copy at Amazon.com for less than $8, counting shipping. Russell Kaplan's book is published by Oxford University Press. It was published back in the 1980s. It is an excellent review and certainly the most thorough review of this process. There are a few problems in it, mostly having to do with the fact that Russell Kaplan did not have as much access to ratification era material as I have had, and we have been fortunate to have, or the rest of us have today. But generally, it is an excellent treatment. The second plug is much more shameless, and that is starting today on the website of the Goldwater Institute, goldwaterinstitute.org, you can get my paper on the founding era and the Convention to Propose Amendments. Surveys the kind of evidence, gives you all the citations I left out in my main talk. And I will tell you honestly that it was written without preconceptions. In fact, when I went into it, I thought that such a convention probably was not controllable. I don't work like that. It's an honest piece of work. It's not a piece of advocacy. Two other Goldwater Institute papers for me are going to come out. One will discuss the 19th and early 20th century examination of the process, and the third one will be an examination of the law of the Supreme Court, and then some recommendations for state legislatures. Thank you all very much. I really enjoy being here.